This show is intended to help listeners understand the new opportunities that are now available to college and high school athletes as it relates to name, image, and likeness. The information contained in this show is only meant for educational purposes and is not meant to be legal advice or to establish an attorney-client relationship. Hello, everyone, and welcome to another episode of Court to Court with the Esquire Coach. I hope you all enjoyed my last episode with Anthony Johnson of Renaissance Sports Group as we talked about being an agent and being an agent in this NIL world within college sports. If you haven't had a chance to check it out here at the link above. I'm sure it will be worth your while. So since 2025 began, there's been a lot going on in college athletics, and we're going to get into it. The NCAA started the year off with their annual convention in Nashville, Tennessee, and there was a good bit of news that came out of that convention, so we will discuss that here in this episode. Also in this episode, we finally got some guidance from the Department of Education Office of Civil Rights regarding how Title IX and NIL work together. So we're going to talk about that as well. The Department of Justice issued a statement of interest in regards to the House settlement. And we have some more exciting college sports news that we're going to get into towards the end of the episode. So let's get into it. As I mentioned, the NCAA started the year off with their annual convention in Nashville, Tennessee. One of the most exciting, or at least I think the most exciting pieces of news to come out of that convention is the creation of the Women's Basketball Fund for the March Madness tournament. Starting this year, teams that participate and advance in the Division I Women's Basketball Championship will earn financial rewards for their conferences. This will begin with the upcoming tournament, and funds will be distributed in 2026. The distribution structure for the Women's Basketball Equal Conference Fund and the Women's Basketball Performance Fund will be similar to that of the Division I Men's Basketball Tournament. According to the press release, the units will be at a combined value of $15 million for the 2025-2026 school year. Then it will increase to $20 million for the 2026-27 school year and reach $25 million by the 2027-2028 school year. The funds after that point will grow at the same rate as it does for all other Division I funds, with an increase at about 2.9% per year. Units earned by participating teams will be paid out to the school's respective conference offers in 2026 on a rolling 3-year basis. This is great news for women's basketball and women's sports in general. The NCAA has been trying to make improvements regarding gender equity, specifically in regards to women's basketball, since 2021 after a viral video showed the disparities between the men's weight room and the women's weight room. Then University of Oregon women's basketball player Sidonia Prince posted a video showing the dumbbell rack that was given to the women's athletes during their tournament for them to prepare for games versus the essentially weight training gym that the men received for their tournament, where they had Smith machines and just all manner of weight equipment that you can imagine, while the women only had a dumbbell rack. So the NCAA immediately took measures to rectify that and improve the women's weight room during that tournament, and they also created a executive commission to review gender equity issues. Soon after that, the women's tournament was expanded from 64 teams to 68 teams, and the women's tournament was finally able to use the March Madness designation. That's right. Before that, the women's tournament was not included in the March Madness branding. But since then, there's been an explosion in women's basketball. The viewership is high. The last 2 March Madness tournaments, Final Four tournaments for women's basketball, has been very exciting, arguably more exciting than the men's tournaments for the last couple of years. And I'm very excited to see who ends up in the Final Four this year for the women's tournament. Another bit of news that came out of the NCAA's annual convention is that they may be considering a proposal to allow college athletes to have 5 years of eligibility. A couple of episodes back, I spoke of Diego Pavia and his case against the NCAA seeking to get another year of eligibility to play college football. Pavia was successful as the NCAA received an injunction stopping him from enforcing the rule that was keeping him from playing football, and he was granted another year of eligibility. In an effort to prevent other situations like this, news broke that there's a concept floating around where the NCAA may consider allowing college athletes to play a 5 full seasons of competition over a 5-year period. And this will eliminate the need for things like red shirts and other waivers and things regarding players' eligibility. So right now it appears that it's just a concept that's being discussed. But tell me, what do you guys think? Do you think that we should do away with waivers and the NCAA's other eligibility rules and just automatically allow college athletes to have 5 years of eligibility over a 5-year period? Let me know in the comments. Now we're going to move on to more news regarding the House settlement. I've spoken at length on the show about the House versus NCAA case and the impending settlement in the case. Well, the last time I spoke about a Q&A that was released for the colleges and institutions and said that a Q&A would be soon coming for the college athletes. In late December, the Q&A was released. So first, let me say, if you would like to learn more about the impending House settlement, please visit www.collegeathletecompensation.com. There you can learn about the case and see these different Q&A documents and other documents that are related to the case. But now I'm going to highlight a few of the questions and answers that was included in the document. So the first one is, will college athletes receive NIL payments from their school? And the answer here is that really it depends. Schools will be provided to provide NIL opportunities for their athletes, but they won't be required to. So schools have an option to either opt into the new programs that are available if the House settlement is approved. That's the big if. You know, a lot of times we talk about this like it has been approved. It has not been finally approved. It received a preliminary approval, but the fairness hearing is in April. And again, you can learn more about that at the website that I mentioned. So the next question is a college athlete scholarship guaranteed? And the answer is that the proposed settlement does not alter any of the scholarship guarantees that became effective August 1st, 2024. With the new scholarship protections, schools cannot reduce, cancel, or fail to renew athletic scholarships in NCAA sports for athletic reasons such as injury, physical or mental illness, athletic ability or performance, or contribution to team success or roster management decisions. Now, one thing that is being hotly discussed right now, and we're even seeing some athletes voice concerns over this issue, is the athletic roster. So the question is a college athlete roster spot guaranteed? And the answer is no. Schools have discretion of whether to include college athletes on a particular team. Schools that choose to opt into the settlement will be bound by set roster sizes, and decisions related to those available roster spots will be up to the school. So this will have an impact on various sports, particularly football, where you are accustomed to having walk-ons. Due to the roster limits that will be imposed if the settlement is approved, the opportunity for walk-ons likely will not be there. And a big one is, do college athletes need to disclose their NIL agreements? So if the settlement is approved, NIL deals, whether with a school or with a third party, will need to be disclosed. College athletes must disclose all NIL agreements with third parties if the involved payment exceeds $600 in total. Let's harp on in total. So if you work with ABC Company on one deal and it's $300, and then you work with ABC Company on another deal and it's $300, that is $600 in total. So that would mean that both of those deals have to be reported because your total amount working with that company is $600. Schools are responsible for disclosing any additional payments of benefits provided under the settlement. And the next question is, what can schools do to help college athletes find NIL opportunities? So when NIL first started, it was stated that schools could not in any way assist, right? But if the settlement is approved, then schools will be able to assist. So in addition to paying college athletes to use their NIL consistent with the terms of the settlement, schools can help find outside opportunities and provide services to support athletes in their search for NIL opportunities, as long as the athlete maintains full control over the NIL opportunity. A couple of more things to note about the Q&A. One of them is that the Q&A makes clear that schools may not make any payments for NIL agreements prior to July 1st, 2025, and all offers must be contingent on final approval of the settlement. So again, here highlighting the fact that the settlement has not been approved. So if you are an athlete that is being offered a deal that has any bearing on this settlement coming to fruition, just be mindful that it has not been approved yet, and that there have been some formal objections filed to the settlement. Whether or not that means that the settlement won't be approved remains to be seen, but it is not a done deal at this moment. And the next one is that schools may not enter agreements with athletes to extend past their time as a college athlete or with collegiate eligibility, other than for continuing use of any content that was created during the athlete's eligibility. I just want to pause here for a minute because I talk a lot about intellectual property and licensing and making sure that you understand your IP rights and what you may be giving away. If someone makes your logo, do you own it? So this part right here where they're talking about still being able, that the agreement as it relates to any content that's created may extend past your eligibility. What they're getting at is your intellectual property, is your name, image, and likeness. So if they, it may say something like the school will still be able to use your NIL in any marketing or things like that, or, any type of content. I just want to draw your attention to a provision like that so that you understand what it's saying and what you're saying that they'll still be able to use. And whether or not, if the agreement say that you will be compensated or not for that continued use. Depends on what the agreement says, but this is what they're talking about. This is what you need to look out for. The Q&A addresses a lot more questions on it. So again, for the full document, you can find it at www.collegeathletecompensation.com. While the NCAA Convention was going on, we finally got some guidance from the United States Department of Education Office of Civil Rights on Title IX in the world of NIL. Since NIL has become a thing for college athletes, many have questioned, how does Title IX apply to this new world order? But before we get into that, let's just briefly discuss what Title IX is. So Title IX is a law that prohibits discrimination on the basis of sex by schools who receive federal financial assistance, including K-12 schools, colleges, and universities. And this prohibition extends to all sports programs, including the athletic program. Schools receiving federal financial assistance are required to provide equal athletic opportunities based on sex, including with respect to publicity, support services, and other benefits, opportunities, and treatment, and that schools may not discriminate in the provision of athletic financial assistance. So before we get into the guidance that was issued, let's rewind a little bit to before college athletes had NIL rights, when it was being debated. So many would bring up, title, that if college athletes were allowed to profit from their NIL, that Title IX would be an issue. And people retorted that it would not be an issue because NIL payments was intended to be third-party deals that would have nothing to do with the school. And if it was like that, it's a strong argument that Title IX is not an issue because it's individual players going out to ABC Company to get a deal. And for about 2 months or a month and a half, that is how it was and what was happening. But then we got NIL collectives, which although they're not technically a part of the school, they were very outward with representing the school's interests. Basically, they were booster clubs who wanted to give their school's athletes NIL opportunities. But that raised significant Title IX questions, as even though the NIL collectives were not a part of the school, they had a significant relationship with the school. So then the question became, do universities have a responsibility to make sure that their affiliated NIL collectives are providing equitable opportunities to women's and men's athletes based on Title IX? So this fact sheet that was issued doesn't really address that specifically, but it does provide some guidance on how the Office of Civil Rights, or at least the Office of Civil Rights during the previous administration, as you know, we just changed presidential administrations. So at least the previous administration, how they would consider Title IX in the NIL world. Per the fact sheet, schools are required to comply with Title IX as it relates to publicity. And this could affect NIL opportunities, because if one sport is promoted over the other, that could affect the opportunities that are available for each sport. So you have to have equitable publicity for each sport. OCR holds that compensation provided by a school for the use of an athlete's NIL constitutes financial assistance under Title IX, because athletic financial assistance includes any financial assistance and other aid provided by the school to athletes that is connected to a student's athletic participation. It is not limited to scholarships or grants. So this means that when the school provides athletic financial assistance in the form of compensation for the use of an athlete's NIL, such assistance must be made proportionally available to male and female athletes. So, as I stated earlier when I was talking about NIL collectives, the fact sheet does not specifically address the application of Title IX for NIL by third parties, including an NIL collective. But OCR does state that the Office of Civil Rights has long recognized that schools have Title IX obligations when they receive funding from private sources, such as private donations and funds raised by booster clubs. As I stated earlier, NIL collectives are basically a group of boosters who come together to provide opportunities for their school's athletes. So the fact that funds are provided by a private source does not relieve a school of its responsibility to treat all of its athletes in a non-discriminatory manner. So even though it doesn't directly speak to it, it still reiterates this point that schools are required to provide donations that are given by private donors, such as boosters, in an equitable manner. So the question is whether or not, if this guidance will hold weight, particularly with this new administration. It has already received criticism from Texas Senator Ted Cruz, who is going to be the upcoming chairman of the Senate Commerce Committee. And he basically criticized it and alluded to maybe it not being supported by the current administration. So we will see how this plays out. As I stated earlier, January was a very busy month for college sports. We had the DOJ release a statement of interest in regards to the proposed House settlement. The DOJ basically expressed concerns regarding the settlement and stated that it may not cure the ill effects of illegal conduct and assure the public freedom of its continuance. Instead, they said that the proposed settlement was an effort to continue essentially price fixing. So the House settlement, or the House case, is a antitrust case, and it's basically saying that the NCAA and the Power 5 conferences colluded together to restrain the college athlete labor market to $0. And now with the settlement, colleges will be able to engage in revenue sharing, but up to 22% of the average revenue. And so the DOJ is saying that All that this settlement does is move the cap from $0 to 22% of the average revenue. And they also highlighted another point that I keep saying, which is the absence of a college athletes union to represent the interests of the athletes. So this decision to cap what universities can revenue share with the athletes was just kind of unilaterally made, even though it was, made with the plaintiffs' attorneys and the NCAA's attorneys, and they agreed to it in the settlement. But in a sense, it was unilaterally made because there's no union to represent all of the college athletes' interests. And the DOJ even made a comparison between the professional sports leagues and their players' unions and the caps that they have on their salaries. And by saying, it's really not the same conversation because there's no union to represent the college athletes' interests. And, another point that I keep making is that I think we're going to continue to see, regardless of how the House settlement turns out, I think we're going to continue to see issues regarding this because there is no union to represent the players' interests. Because the professional leagues are able to cap compensation because the presence of a union kind of gives that antitrust law buffer. Without that here, I'm not seeing how the NCAA is going to continue to get around this issue, even with the mechanism of trying to prevent future lawsuits regarding this if you opt into the settlement. But it is unclear how much weight this statement of interest will have, basically for the same reason as the Title IX fact sheet, because we've had a change in administration. So we'll see what happens, if that affects us at all. And again, we have the fairness hearing coming up in April regarding the proposed House settlement, and we will just have to wait and see if it gets its final approval. So EA Sports announced that it will be in the game again, as they said that the college football video game will be returning with the new edition this summer. So last summer, EA Sports released the first college football video game since NCAA Football 14. You can check out my interview above with Matt Brown of Extra Points as we discuss the return of the college football video game and the reason why it left. So with the return of the game last summer, college athletes were afforded the opportunity to get a piece of the pie and was able to profit from the commercial use of their name, image, and likeness in the game. And the deal that most athletes received for those who opted in was $600 along with a copy of the game. The game's cover out athletes, the athletes who appeared on the cover, got another deal in addition to that one. But those deal terms haven't been disclosed, but they did get an additional deal. At the time when it was announced that the athletes would receive $600 in the cover of the game, I questioned whether or not if it was really enough, specifically because there was no opportunity to get royalty payments. I thought that the game may be successful and that the athletes could really benefit from getting royalty payments. Turns out the game was super successful. EA Sports College Football 25 was the best-selling video game of 2024. It became the best-selling video game in U.S. history, surpassing NBA 2K21. And according to data from Research and Analytics, the game made the top 50 best-selling video game list of all time. So, yes, the game was wildly successful. You can clearly see why it's coming back for 2026. And to my understanding, the deal terms for the athletes may be different this time around. So I will keep you all abreast of the return of the second iteration of the college football video game and the deal that will be available for the college athletes this time around.